Okay, let's get the jury in. Thank you, Deputy. Oh, excuse me. Can you tell the deputy hold up one moment? Oh, okay, just one moment. I just wanted to cover one thing. Ms. Potter, do you still want to testify, or have you changed your mind?
Yes, Your Honor, I'll testify.
Okay. And you don't need any more time to think about that?
No, Your Honor.
Okay. All right, Deputy.
For the record, we have talked at length about that.
Okay.
She wants to testify.
All right. Okay.
Can I get my witness too?
Yes, please. Okay, please be seated. Members of the jury, I apologize for the delay in getting started this morning. I had to deal with some legal issues. And I want to also explain to you that yesterday there were some times that we had headsets on. We were discussing legal matters. We're not trying to hide anything from you, so I hope you understand that. But it's very important that you only consider evidence that is properly before you in rendering your verdict. So I know it can be frustrating, but I want to be careful, and I want you to consider the right evidence. Okay? The state or the defense may call its first witness.
Call Steve Ijames.
Yes. Come forward, please. And would you stand behind the witness chair? And raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this case?
Yes, ma'am.
Please take the witness chair and please remove your mask. State your full name and spell it.
Stephen Bradford Ijames, S-T-E-P-H-E-N. Bradford is B-R-A-D-F-O-R-D. And the last name is Ijames, I-J-A-M-E-S.
All right. There's a court reporter taking down everything that's being said, so you have to follow certain rules. You have to answer yes or no instead of shaking your head. No, uh-huh, or uh-uh. If you don't understand a question, let the lawyer know. Only one person can speak at a time. So wait until the question's finished before you answer. And most importantly, if an objection is made, stop talking immediately. Do not answer the question unless I tell you to.
Yes, ma'am.
Counsel?
Thank you, Your Honor. Mr. Ijames, how old a man are you?
I'm 64, sir.
Where are you from?
Springfield, Missouri.
Did you drive up here yesterday?
Yes, sir.
Tell us about your education, your undergraduate degree and a master's degree.
I have a bachelor's degree in criminal justice and a master's degree in public administration.
And do you remember when you got those?
80s and 90s.
Okay. You've had a career in law enforcement, have you not?
I continue to be commissioned as a Class A peace officer in Missouri today, yes, sir.
How many years have you been a police officer?
I'm in my 44th right now.
Okay. Have you attended, in the course of your career, certain law enforcement academies?
Yes, sir.
Could you tell us what those are?
Initially, the Missouri State Highway Patrol Academy, and then the Springfield, Missouri Police Academy, which is an internal 1,000-hour academy. As for basic police training, that's the two initial academies I went to.
Did you attend the FBI Academy?
I'm a graduate of the 186th FBI National Academy, yes, sir.
Could you tell us a little bit more about that? Where did that take place?
It's in Quantico, Virginia, and it's considered the premier training for law enforcement managers and commanders in American policing. We also do foreign countries. I think there's been 117 countries that have sent senior police commanders, but it's primarily an American police finishing school for commanders.
Have you been to the DEA Academy as well?
Yes, sir. Graduate of the DEA Academy also.
And what was involved in that?
That was a 2-week commander's academy simply for running drug schools, drug programs, basically a focused command effort to teach you to do a better job of doing safe and effective policing in a pretty complicated area, the drug world, and that's what their
I suppose we
program
ought to say what the DEA means in terms of those initials.
Sure,
what
Drug
does
Enforcement
DEA mean?
Administration.
Let me ask you what your specific experience is in law enforcement and a number of your other qualifications before we get to this case. Tell us about your law enforcement career. How did it start and what did you initially do?
As with almost every police officer, I started as a basic patrolman, driving a patrol car, answering calls, just your general call for service. Promoted from there to a narcotics drug investigator, and then from there to just a general crimes investigator, your basic TV detective. I left a smaller department after 3.5 years, primarily to get my 4-year degree. I moved to Springfield, Missouri from Poplar Bluff, Missouri, and went back through the academy. Policing is unique, in some ways good, some ways bad, but it's not a profession by many standards. For example, when I moved from one department to another, I went right back to school. It wasn't like since I had been a police officer, I just come to work. So in Springfield, regardless of my detective experience, I went right back to the academy for 1,000 hours and then 13 weeks of riding with a training officer.
So
And
let me
then-
back up. Did you start out with the Poplar Bluff Police Department?
Yes, sir.
And then after a certain amount of time, you went to Springfield, the Springfield Police Department. Is that
I was
correct?
in Poplar Bluff for about 3.5 years, and then to Springfield, was there for 25. I retired there as the assistant chief. But the beginning is right back to the street. So I did several years as a patrol officer after the academy. I rotated in to work the jail for 9 months. We had a 14,000 prisoner a year jail booking process that if we were short on civilians, they would grab the low senior people. So I did 9 months in the jail. I dispatched for a while, worked the front desk. You just do whatever they tell you to do in the early days especially.
Did you advance through the department?
Yes, sir.
Tell us what your advancements were.
After several years in those assignments I just mentioned, I was transferred to an undercover narcotics role, where basically bought hand-to-hand drug buys off about 300 suspects. Ultimately promoted to a detective corporal, which is a plainclothes investigator, kind of what you see on TV, doing every type of post-event investigation, robbery, homicide, theft, that sort of thing. Ultimately promoted to sergeant in the detective division. And then in 1989, a catalyst event, a pretty catastrophic hostage-taking scenario, resulted in us creating a full-time SWAT team versus a part-time team that would not be as practiced and experienced.
What's a SWAT team for our own?
Special Weapons and Tactics is what the terminology references, but it's basically a group of officers. It varies by department, but for most it's an elevated skill proficiency group that focuses on really critical incidents, day in, day out, your drug search warrants, barricaded suspects, hostage takings. And we had an event that finished well, but it wasn't because we did well. We had a hostage taking that finished successfully, but because the suspect allowed the victim to be released. And the chief recognized after that we simply didn't have the capability as a part-time team to solve it. And so he created a full-time team. I was asked to lead that team. And when I say full-time, just to be clear, most SWAT teams in America, about 98%, have collateral duties. They work in patrol, they work as a detective. In our environment, it was the only job we had, 10-hour training day a week, and nothing but search warrants, barricades, and the rare hostage taking. So I had that team for many years.
About how many, you remember?
As the direct supervisor, first line person, 89 to about 94. I kept it in my division as command almost to the last day I was there, but functionally, once you make captain, you're not an operator anymore. You need to allow line people to work. So once you're at that level, I stopped doing the day-to-day work with them.
And what other responsibilities did you have after that with the department?
When I promoted to lieutenant from that division, I kept supervision of SWAT, but I also had narcotics. So you had all drug investigations, all special operations, K-9, bicycle unit, just odd things that police departments lumped together. Ultimately promoting to a captain and took over the uniform patrol division, which would be everything you see in a uniform, from a DARE program, drug abuse resistance education, to uniform patrol, to a school crossing guards, just everything you think uniform policing. About 3 years later, I think I was promoted to major and took over all investigations, which would take you out of uniform, but then anything, plainclothes, narcotics, robbery, homicide, anything that would be your perspective of a plainclothes detective, and I had that role until I retired as the assistant chief.
Along the way, while you were at the Springfield Police Department, did you work with the United States Marshal's Office?
I was a commissioned marshal on a number of task forces at various times in my career. There's reasons why agencies do that, to give you a different level of authority. And there's also some funding reasons why you do that. You can get money funneled to a department to help with overtime and things like that. But on a number of occasions, yes, sir.
Did you also work on a DEA task force while you were at Springfield?
On a number of them, yes, sir.
You indicated that you were a licensed police officer for 43 years. Have you considered now retiring from active duty, so to speak?
As recent as 2 months ago, I was driving a marked patrol car for the State Park Police, the Park Rangers. I've done that for the last 3 years. Had some medical hiccups that have caused me to resign that commission, but I'm not sure what will happen after the first of the year. But I'm leaning more towards family stuff. But
Well, you
we'll
know,
see.
you've come up here in a car. Did you recently have heart surgery in Chicago?
Open heart surgery last week.
Which is one of the factors you're considering in retiring.
My wife's certainly considering that, yes, sir.
Okay. Do you know what a critical incident is?
Definition varies from agencies. There's no national standard definition, but for most agencies, it's an incident that involves an enhanced potential for death or serious physical injury over your ordinary day-to-day call.
In your 43-year career, how many critical incidences have you been involved with?
I couldn't begin to answer that. I mean, it'd be many, many, many.
Can you give us an estimate?
Hundreds.
And were some of those critical incidents involving guns and shots fired?
I would say the vast majority, not that you can't be in immediate deadly jeopardy with something besides a gun, but normally, because the gun issue involves distance and capability, you can usually stay away from a knife person to some degree, but most of them involve guns because they're harder to control.
Do you have any teaching experience?
Beginning in the late 80s, I became a generalist and specialist instructor for the Missouri Department of Public Safety and began just teaching in Missouri, primarily drug-related investigations, and then as our SWAT team evolved, began doing SWAT training. Not because, we were the best, but we were busy and we had good outcomes. We were able to get the job done without anyone getting hurt. And in policing, you quite often look to others who are doing something that seems to be where you want to be, and you learn from that. So we began doing a lot. I began doing a lot of tactical training. There's an international organization called the NTOA. It's the National Tactical Officers Association, but it has 40 countries represented. Began teaching for them. In the late 80s, early 90s, we began videotaping virtually everything we did, which in American policing, that was just stunning, that you would videotape what you were doing, and many, many people question the logic in that. For us, it was primarily a critiquing, learn from training perspective, but because we had video, of operations, of things going well, things going bad, it greatly enhanced the teaching capability. So I could show videos of actual operations. One thing led to another, and I was asked by the director of the NTOA to be one of their 4 national board members. So once I became on the board, a key part of that was teaching for the National SWAT Association.
Well, let me interrupt you then. Let me list a couple organizations you've taught for, if I may. Have
Yes,
you presented for the United States Department of State?
In 33 countries, yes, sir.
Have you presented for the International Association of Chiefs of Police?
Many, many times.
And you've made presentations in many states in the United States, have you not?
Yes, sir. I think pretty much everywhere.
You have made presentations on the international arena in Somalia,
Yes, sir.
Haiti.
Many, many times in Haiti.
You've made presentations to SWAT officers in London, Amsterdam, Brussels, Dusseldorf, Nuremberg, Belfast, among other places.
33 countries, yes, sir.
You've made presentations for the United States Department of Justice in Bosnia.
Yes, sir.
You've also worked as an evaluator for various countries and how they operate their police forces and their SWAT teams. Have you not?
Not unique to foreign countries. I've actually done more evaluations here in the United States. That's actually a key part of what I've done, especially in the last 10 or 15 years, is do evaluations for agencies that would just like an outside external perspective. In some cases after a tragedy, a critical incident, but in some they'll invite you in and say, hey, I've just taken over this department and it looks good to me, but I would just like an outside look, someone who doesn't have a dog in the fight. So I do a lot of that, more in the United States, but I have done a lot overseas, but more here.
Well, let me ask you whether overseas you've worked with various countries, including Jamaica,
Yes, sir.
Canada,
Yes, sir.
countries in Southeast Asia,
Yes, sir.
Tanzania,
Yes, sir.
Greece,
Yes, sir.
Yemen,
Yes, sir.
Kenya,
Yes, sir.
Indonesia,
Yes, sir.
and that's just a start.
Been to a lot of them, yes, sir.
Okay. And you've also trained officers in terrorism and counterterrorism, have you not?
A key focus of the international training, not surprising when you consider the last 20 years or so, post 9/11 for sure, a critical focus of our U.S. government effort overseas that involves local police. A lot of individuals don't understand that much of the American policing effort overseas that the U.S. government funds is done by police officers, not the military. Nothing wrong with the military, simply that our government, I believe, thinks that it's best for police to train the police. And so post 9/11 especially, a key focus of what I've done is under what's called a anti-terror assistance training program, which is through Department of Justice or state, geared towards teaching concepts that just make our embassies safer and make our citizens safer in countries that might have a potential for enhanced risk for terrorism. Yes, sir.
Okay. Have you made presentations and worked with the United States Army, the United States Air Force, the New York City Police Department, and police departments in California, Wisconsin, Oregon, Utah, Colorado, Illinois, among other places?
Been here a lot of times.
You are an instructor for tasers, are you not?
Not for Taser. I've never worked for the company.
How does that work when you say you didn't ever work for the company? Tell us how one becomes an instructor on tasers.
So Taser was invented in 1965. A man named Jack Cover, and it went through a number of different patents and owners, but ultimately the Smith brothers, Rick and Tom Smith, took over the Taser patents in the mid-90s, slightly varied to get around some technical issues, but in the mid-90s, the Smith brothers created the current process that became the Taser today. And in 1999, they did their first instructor-trainer program where they would create training to teach teachers. And that first program was done in my police department by Rick Smith, the owner of the company. And I was in that class. And I always felt like that I had been training for a number of years up to that point, that if you ended up appearing to be in bed with a company, if you worked for a company, that your ability to speak truthfully without people wondering what your motivation was would be an issue. So I just made a decision in the mid-90s to, though I was very involved in technical training, whether it was pepper spray, whether it was a plastic bullet, tear gas, I would never work for a company, because I just felt like you kind of have to carry the party line. And so Mr. Smith allowed me to go through that class with the understanding that I would not be a Taser instructor. In the early 2000s, there was a lot of controversy with police departments being accused of being too tightly aligned with manufacturers, getting free things, basically using tools on citizens in scenarios that might be questionable. And so you began to have training crop up where individual agencies wanted teaching from outside of a company. They basically didn't want the party line. And so the International Association of Chiefs of Police, who I've been involved with for years, largest and oldest police organization in the world since 1897, had me develop a Taser program. We actually couldn't use the term. It was Conducted Energy Weapon, CEW training program, to where we could teach agencies Taser process, but not be under the Taser banner.
And you have taught Taser courses.
Many.
Okay, you're familiar with the protocols for the current Taser, Taser 7.
Both the teaching and then what we would call your best practices policies that are out there. There's different groups that give models, examples of how they think the device should be used. Not all in lockstep, but I'm very familiar with those as well.
Well, we're almost done with your qualifications, but I want to ask you just a couple more questions. Have you had any academic affiliations where you're taught policing and criminal justice matters at a college level?
Yes, sir. I've taught seated classes at different universities. 3-day-a-week classes, and then I've done just adjunct faculty, things like that. I don't do anything like that now, and I don't anticipate it again.
How many officers over the course of your 43 years do you estimate that you've trained in the reasonable use of force, including tasers and guns? Give a sense of how many people you've trained.
It'd be thousands. I don't want to just guess. It would be thousands.
Have you received any awards during the course of your career?
Some, yes, sir.
Well, are you a member of the American Police Hall of Fame, for example?
Yes, sir.
And what is that?
It's just a national police organization that recognizes certain acts in police service.
Are you the recipient of the Silver Star for Bravery?
Yes, sir.
What is that?
It's an award given for actions that meet their standards to acknowledge, I guess, above and beyond the normal duty.
And what did you get the award for?
Rescuing a hostage in a liquor store holdup that had been shot, and engaging the suspect in that case and shooting and killing him.
Have you had any publications during the course of your career?
Around 100 articles, chapters for books, peer-reviewed articles, some not, but I would estimate around 100.
Mr. Ijames, I could spend quite a bit more time with your qualifications, but is the history of your career set forth in your CV, which is Exhibit 1001?
Yes, sir.
We offer 1001 for the defense.
Is there any objection?
We do, Your Honor. It's hearsay.
It's his resume, correct? The objection is overruled and the exhibit will be admitted.
Did I contact you or the defense contact you for the purposes of your initial review of this case?
I don't remember.
Well, you were contacted. It doesn't matter who, but
Yes,
you were
sir.
contacted
I don't
to see
recall.
if you would review this case, were you not?
Yes, sir.
Okay. All right. How many cases have you reviewed for reasonable use of force, excessive force, that sort of thing in the course of your career?
A fair number would be between 2,000 and 3,000.
How many criminal cases do you have right now under your review?
4.
Of the 4 cases that you have, how many of those are you testifying for or on behalf of the police officer or against the police officer?
This is the only one that would be considered, if that's the perspective, for an officer. The other three, my opinions, would be against the officer.
Are we paying you to be here?
No, sir.
And why is that?
I've decided in the mid-'90s, when this process began, I began asked to review cases that I would never take a fee in a criminal case, regardless of the side that was calling me. I'm not Mr. Benevolent. I like to get paid like anyone else. But I just felt that something as significant as someone's freedom suggested I should give an opinion without any question about motivation. I may say things you don't agree with, but I don't think the issue of money coming into it should be a consideration. So I just decided in the 90s I would never take a fee for a criminal review of any kind, regardless of the initiation, but I've stood by that, and if I continue to do this, I'll continue to take that perspective.
Well, we asked you to review this case. Do you remember initially what you did review?
Yes, sir. It was a voluminous file. As I recall, our initial discussion focused around the deployment of a taser. That was the primary focus. This case, and in no way am I diminishing, it's not a complicated case, the facts itself, but the focus initially was the issue of a decision to deploy and manner of deployment of the taser.
So you looked at the videos,
statements, various reports. I didn't review everything in it. I reviewed those things I felt were necessary to give me the information to render reasonable opinions concerning the decision to deploy and the manner of deployment of the taser. Yes, sir.
Which really centered on the officers on the scene, Mr. Wright's conduct, and the
And then
training.
some foundational stuff, issues concerning what an officer would have been taught, what would have caused them to think certain things, but almost exclusively it's the officers on the scene. Yes, sir.
Now, since the trial began, have you reviewed actual testimony that the jury has heard?
In the last week, within some limits of my ability in the last week, I was able to follow some things that were online that involved testimony. Yes, sir.
Did you, for example, follow the testimony of Officer Lucky,
Yes, sir.
Sergeant Johnson,
Yes, sir.
Sergeant Peterson in training,
The training sergeant. Yes, sir.
and also Mr. Stoughton yesterday?
Yes, sir.
Well, let's start your review by your understanding of what happened here. Would you discuss the nature of the stop and what you saw, and then I'll get you some more specific questions on the use of the taser. What did you initially see in your review?
Yes, sir. You've got an officer in field training and a recruit, for lack of a better term, and there's an initial assessment of the vehicle in front that has something hanging from the mirror. Your state, as with other states, has a statute that says you can't have anything between the driver and the windshield. And so I think that was the initial reference. Field training is a process of work. You want recruits to do things and test them and figure out that they understand the basic practices and protocols. So the license was checked. There determined to be some difficulty with, I believe, the registration tabs. So you had basically your statutory issue about something hanging between your eyes and the windshield, and then a license violation, and the stop was initiated from there.
Was the matter of a warrant for a gun of significance to you in any way? The fact that the officer on the scene found out that there was a warrant outstanding for the driver of the car.
Oh, yes, sir.
What was that? Was that significant for you in any way?
Yes, sir.
And how so?
Police officers aren't clairvoyant. The best way to indicate what might happen tomorrow is what happened yesterday. So we teach officers to act on reasonable appearance. And so if I find a person on a stop that has a weapons charge or a gun warrant, it doesn't mean they have a gun. It means they very likely could have a gun because they've had one in the past. So an officer would immediately take a different perspective, not that they would act necessarily differently, but they would begin to address this call for service differently because we have reasonable, objective information that a gun could be in play.
How about the existence of a harassment order? Did that have any import in your evaluation of the case?
Same basic thought process. We teach officers to look at the totality of circumstance, everything involved in this case. So if we have, in this case, a female in the car, and we have a harassment reference as well, is that the person? What's the nature of the harassment? It just continues to elevate an officer's vigilance. And I want to be clear, it's not that we then use weapons or use force, but we absolutely look reasonably on appearance of the facts we learn as we move forward about potential danger, potential resistance, and then act accordingly.
Well, does the harassment order increase or decrease an officer's possible perception of dangerousness?
It would increase. I mean, it's certainly different than a felony assault, but it's also different than a shoplifting charge. So harassment would indicate a personal interaction in a negative way, and it would just cause an officer to be more vigilant concerning that type of interaction.
How about the existence of the female passenger in the car? What significance was that to you?
The third party present, officers basically look at calls for service from a safety priority perspective. So that third citizen in there, not the focus of the event, increases your concern for her safety, but also what role, if any, she plays in that harassment charge. Is that the person named in that particular event? Have they made up? People do. It would be very relevant to continuing that investigation.
With a bench warrant outstanding for the driver, was there, in your view, an obligation to arrest him, meaning Mr. Wright?
Absolutely a mandate.
We have an opinion yesterday that the officers could have let him go because he could have been arrested later. And your response to that?
I'm going to object, Your Honor, as a statement of evidence.
The objection is overruled.
Police officers enforce the law. The order from a judge, in my experience, is literally the highest order we operate under. And if a court order, a warrant from a judge says that person is subject to arrest, they will be arrested, and there's consequences if you don't. Some states, including mine, criminalize it. If you don't serve an arrest warrant, it's a crime. Not every state, but that emphasizes the seriousness of it. It's not a request. It's not a suggestion. An arrest warrant is an order to arrest, and that's what police officers do.
So in your view, Lucky, former Officer Potter, and Johnson had to arrest him?
Dereliction of duty not to.
You know, as a supervisor, you know, in Missouri, one of the leaders of the department, would you have disciplined an officer for not executing or not arresting on a warrant from the court?
Beyond question.
Now, turning to the Lucky's behavior and his actions, you remember that he goes up to the car and asks Mr. Wright to step out. Is that correct?
Yes, sir.
Was that a correct police procedure in your view?
Yes, sir, it is.
Was it a correct police procedure in your view to tell him that he was, once out of the car, under arrest?
Beyond question.
And why is that important to tell someone like Mr. Wright that he's under arrest?
It may seem obvious that we would tell people they're under arrest, but in my experience, it quite often doesn't happen. An officer knows there's a warrant for you, and they stand the person up and say, turn around and put your hands behind your back. But it is a critical aspect of that officer-citizen encounter at the time of the arrest to look right at them and say, you are under arrest. And so in this case, we had two officers that actually said it. I just want to make it clear that the assumption that that always happens, it really doesn't. And so it's critical because it basically removes all confusion. When we say you're under arrest, that's exactly what that means, and you're required to comply with that order.
But what does Mr. Wright do instead of complying?
He initially just stood there and fidgeted a bit, and then there was the attempt to cuff him, and then he ultimately tried to get back in the vehicle.
In your 43 years, when someone wants to not be arrested and are about to be cuffed, what usually happens?
First handcuff's where it happens. When you take a hold of that first hand and are applying the first handcuff, in my experience, and that's taught universally, but it's like at that moment when they make the decision is when the hand goes on their hand, and that appeared to be what I saw in the video. It's the norm, but he began resisting at that point.
And what impact did that decision that Mr. Wright made have on the police officers at the scene?
Objection, Your Honor, calls for speculation.
The objection is overruled. He may answer.
It changes everything.
How so?
In policing, our primary focus is to react to what others do. There are certain areas we're proactive, but as in this scenario, we are reacting to what the arrested individual does as it relates to submitting to our lawful authority. If he complies, as almost every prisoner does, the handcuffs go on and the process works itself out. If they resist, then we will have to use that level of control to overcome the resistance and continue to work towards that lawful objective, which is effecting the arrest warrant.
Could the officers, in your view, just kind of let him go when he started to escape from the cuffing?
Objection, asked and answered.
The objection is overruled.
You may answer.
No, sir. Police officers are under authority. We're not military, but in many ways, police officers are structurally in a system where they do what they're told. And they are told to serve arrest warrants. And now, is there room for variation? Do some agencies do other things? Sure. But the legal obligation to serve an arrest warrant is unquestionable. And at the time he resists, their default is to overcome the resistance in a reasonable, safe way and get back to working on accomplishing that mission objective, which is to serve the arrest warrant.
Did you see from your review of the videotapes and the testimony that you've heard and watched that there were efforts after Mr. Wright initially refused to be cuffed to secure him?
Yes, there was an initial scuffle there at the driver's side. Yes, sir.
Was that a legitimate law enforcement technique?
Certainly. Grappling, soft empty hand control is the formal term, is the force used in about 90% of all resistance. I try to put a cuff on you, you begin to scuffle. I don't punch you, you don't punch me, we're just in a little bit of a grapple. And if I and my friends are able to overcome your resistance, the handcuffs go on, and that's that. Almost every time, that's what we do.
We've talked in the trial about control over a motor vehicle. Are you familiar with that phrase?
I
am. Was at this point in time, or was this at this point in time, was Mr. Wright in control of his vehicle as he struggled to get back in it?
He was not.
Was he ever in control of the vehicle before the taser was shouted and a gunshot took off?
Not that I could tell from the video, no, sir.
What do you mean by control in police work?
Control literally means the ability to put it in drive and go. That's it. There's actually a Minnesota statute that references control in relation to DWI, and it talks about mechanisms of movement. That's not unique to Minnesota. Literally, control is just that. I'm in control, and I can go do what I want, which in this case was likely to go forward.
We've seen a lot of body cameras in this case, and then we've seen still shots of what happens. When an officer is in a situation like they were here, do they see in still shot framing what has happened?
No, sir.
Well, why is showing a still shot of what occurs different from what an officer sees?
The format for body cameras is called QuickTime Player. It's 29.5 frames per second. And you and I can just envision how well we could take a 1 second sliced 29.5 times and accurately or effectively see and assess that slice. So the slice is helpful in some cases, for example, to show whose hands are on a gear shift mechanism. But to suggest that anyone, officer or citizen, sees and perceives something you see in a 1/29.5 second frame is just completely unrealistic.
Well, compare what the body camera sees with what an officer sees when there is a struggle.
Sure. Officers, like all human beings, have varying processes physiologically, metabolically that apply to survival, stress, fear. And so, for example, you'd asked earlier, sir, about critical incidents. I've reviewed hundreds, in which officers and citizens are talked with after a life and death scenario. And very common themes occur where vision is focused, very tunneled. Not always the same, but that's a very common theme, where loud sounds are silent or not heard, where a quiet sound is actually magnified. So the video records exactly what's happening without any of the processes human beings go through. In my experience, in critical incidents, almost no one, officer or citizen, can ever accurately speak to what happened in all areas because their body just can't record, like a video, exactly what's going on.
I would object to that question and answer is beyond the scope of this expert's foundation.
Okay, no speaking objections. You may put your headset on. The objection remains overruled.
As he got back in the car, Mr. Wright got back in the car and struggled. In your view, did he have control of that motor vehicle at that point in time?
He didn't, because he didn't leave.
The gears were not engaged.
Correct.
We've heard testimony yesterday about the differences of shooting into a car that's moving and shooting into a car that's stationary or in control.
Yes,
Is
sir.
that a distinction you make in your work?
It just depends on the circumstances. The key issue is balancing the need to use that extreme level of force with the potential consequences. You may need to do it if the vehicle's moving, if someone's about to die. And then you acknowledge there's potential consequences as it rolls. So it's not a black or white yes or no. It depends on the totality of the circumstances in each case.
You were asked to evaluate the decision to use a taser in this case and whether it was reasonable and appropriate. Is that correct?
Correct.
What is the standard that you're using to make that determination?
Quite often there's terms thrown around in American policing about standards, and to be candid, there are few actual standards as compared to other professions. By standard, I mean if you don't do it, there's action. There's something that follows. We have the Supreme Court, we have federal circuits, we have state statutes that provide standards that if you don't follow, there's consequences. But most of other policing is the result of organizational culture, training. There's 18,800 agencies in America that do many things to a degree of autonomy that is stunning to many people. So, from a standards perspective, what I prefer to teach is what I call contemporary police practices. And by that I mean it's what most people do. It's not that they have to do it. There's not a Supreme Court ruling or a statute. There's not a standard that they're in trouble if they don't. It's what most professional, smart police agencies do. And so to talk contemporary police practice, you have to look for where that body of knowledge would likely be. For me, and for most agencies, organizations like the International Association of Chiefs of Police, every chief in America is a member, been around since 1897. In 1987, they partnered with the Department of Justice to create the National Policy Center. And the National Policy Center was created to put together, their words at that time, models of policy on contemporary issues that agencies could use some help on. And so I've served on the National Policy Center board for over 20 years and authored many of their policies. So if you were a chief in the mid-90s when Taser first became common, what do we do with this thing? How do we use it? Well, the manufacturer says this, and many smart chiefs would say, I appreciate that, but I'd like to talk to some people who worry about what I worry about, not selling devices. And so the Iacp has a model policy on the use of the Taser.
And what would that be?
Well, I wrote that policy. I created it for them, and it specifically speaks to basis or justification to use. And the general justification or basis is grounds to arrest or detain and a reasonable belief that physical force or resistance to that arrest will follow. That's not a mandate to use, but that's a general authorization.
Is that standard dependent on a proportionality of risk, or is there any concept like a proportionality? Sorry about that. In the standard that you've mentioned.
No, sir. The issue of proportionality in policing and force is a very lofty, worthwhile goal, but it's not a standard like objectively reasonable from the Supreme Court to that degree. We want proportionality. We want to do things that are balanced and that make sense. But specifically, officers are instructed that their force has to be reasonable, which in some cases would not be the least amount of force possible. It may in fact be more than something else that you could have done, but that doesn't make it unreasonable.
So is the standard that we use for the reasonable use of force objective reasonableness?
That's the standard I've always been instructed on, yes, sir.
So you've reviewed the Taser manuals in this case, the PowerPoints.
Yes, sir. Very familiar with
You're
that.
familiar with everything that was taught here.
Yes, sir.
So let me ask you the questions that you're here for. Okay?
Yes, sir.
Was the warning given by former Officer Potter, I'll tase you, reasonable?
Yes, sir. That's the standard warning. You just communicate in plain English.
It's a standard. That is what they're taught to do.
Yes, sir. I'll taser you. You just tell the person, and in many cases, someone submits. They'll raise their hands and say, I quit, and that's the goal.
Was the warning taser reasonable under the circumstances in this case?
That is specifically taught in the lesson plan. Number of reasons for that. It's really not for the suspect. It's more for the officers and others around the event to understand that a taser is just about to be deployed.
We heard testimony yesterday that the taser in this case was, or the assumed use of the taser was too close to Mr. Wright to be effective in its impact. Do you agree or disagree with that?
That's completely untrue.
Well, tell us why Mr. Stoughton's opinion is completely untrue.
Two key reasons. The first is the Taser 7 specifically is designed to have a very wide arc with the close range deployed probe. The standard arc deploys about a foot every 7 feet. And one of their corrective measures with the 7 was to figure out that many police confrontations with suspects are at close range, and that degree of spread was insufficient to get neuromuscular incapacitation. So, number one, the 7 spreads wide at close range by design with the close cartridge. Independent of that, the physical positioning of a seated suspect changes everything.
How so?
Literally, as you or I sit here, if you envision a shot just below the chest or sternum area, which is a key aiming point for the upper probe, from that probe to the probe into a thigh is about 12 inches, which is marginal for neuromuscular incapacitation, as they say, as the crow flies. But on the body, it's about 36 inches. Because as you stand, the electricity takes the path of least resistance. It doesn't go through the air. It follows the body. And to connect one probe to the other, it goes down the side, down the leg. And so a seated suspect changes everything as it relates to probe spread, because their body's bent, and you end up hitting low and hitting high, not because you're at a distance correct for that, but because of the angle of their body.
What would have happened had the taser, an actual taser, hit Mr. Wright vis-a-vis his ability to drive that car?
The actual taser device, when it performs as designed and intended, is the most effective incapacitation tool I've ever experienced, independent of a central nervous system disruption. And I apologize for being graphic, a gunshot to the head, something that basically turns off the lights. The taser is the second best thing out there when it performs as designed and intended. In actual operation, it's a relatively fragile system. Things can happen. Clothing can be lofty. A probe maybe won't stick. The very best studies out there, the most recent, January 2021 with LAPD, is all excuses aside, the Taser actually accomplishes overcoming resistance about 67% of the time. So to answer your question, if it had performed as designed and intended, you would have had a neuromuscular incapacitation, which is a very significant physical lockup. In my experience, some people can do a little better than others, but most, it's not a matter of toughness. It's a matter of electronics, physiology. They're pretty much locked up. To get to a shift or a drive would be very, very unlikely in my experience.
And to drive thereafter would be unlikely too.
Objection meeting.
Well, I'll let you answer. The objection is overruled.
As long as continuity exists, as long as the trigger is pressed or the cycle is energized, and both probes have continuity, it will in theory do what it's supposed to do. But the second that breaks, whether they're driving away and the cord breaks, it pulls free, many suspects literally leap back into the game because it's electricity. And when it stops, now some people, oh gosh, that really hurt, and they kind of pause and seem stunned, but the idea that this is like pepper spray that carries after, it is either you're getting the electricity or you're not. And so the answer, sir, is if the cord broke, if it pulled free, in my experience, most human beings no longer have NMI because the electricity is simply not there, and their ability to recover and continue controlling their body would exponentially be pretty high.
Yesterday, we also heard an opinion that given the location, the close location of the officers at the scene, that shooting a taser would be inappropriate in light of where they were. Agree or disagree?
I disagree with that.
And why is that?
Police officers have to deal with the circumstances presented to them. And in actuality, we fight in close proximity with citizens, suspects all the time. And so you have to work around those as safely and practically as you can. And there is a risk. You can make a mistake. One of the very last arrests I made before I retired, I had a fellow officer spray me with pepper spray in a fight directly in the face on the ground. It can happen, but it's a balance between the need to use that tool, the potential benefit of the taser, with the risk of what would happen if you'd hit the wrong person. So we shoot close all the time. You can make a mistake, but it does not prevent you from doing what you need to do in most scenarios.
Was one of the considerations, at least in your review, of the potential danger that would result if Mr. Wright were not detained by the taser?
Just what comes with a fleeing suspect.
Tell us more about that.
No one has a crystal ball, again, to predict what a person would do, but the very nature of flight and resistance brings with it danger to people in the path of the runway. Theoretically, danger to a person in the vehicle if they are subject to that harassment warrant, which you don't know. Many unknowns. But again, the reason we serve arrest warrants is to put that process in front of a judge and stop it right there, because few good things follow when a person flees arrest and gets away.
And one of the dangers here, according to the testimony you heard, was the possibility of one of the officers being dragged.
I did learn of that last week, yes, sir.
And do you have experience with officers being dragged?
We recently retired this year an officer from my department who was permanently disabled, having been drugged in a very similar scenario, and was medically disabled. He's done.
Object, Your Honor. Relevance and notice.
I'll move on.
Yes, please.
And ask that it be stricken.
Well, I object to that.
Well, I am going to advise the jury you should disregard that last statement.
In light of your review and the review of all the testimony that you've seen, was Officer Potter's perceived use of a taser consistent with contemporary and professional police training and practice?
Yes, sir.
And why?
The basic model policy definition of when the device would be used is completely relevant here. Grounds to arrest or detain, and a reasonable belief that physical force and resistance would follow. That was happening right before your eyes. And secondarily, when the physical control effort began and the dynamic nature of how he's trying to get away clearly needs to be stopped. Just getting in the vehicle is significant, but officers would be aware of that weapons component and the concern, could there be a gun in the car? Could there be a gun on him? This isn't just about might this person drive away. So the need to stop it as quickly as possible is the key aspect. Nothing but the taser in that scenario had a likelihood of doing that without a risk of serious injury or death. The continued grapple, if you don't get that done and that car gets in drive, it's going to get bad. And the taser is that unique device that when performing as designed and intended would have put a stop to it very, very likely in most cases.
Did you change your opinion as to whether her perceived use was consistent with the standards you've described after watching the videos of Lucky and Johnson et al.?
No, sir.
What you didn't see in your initial review of the case was Johnson's testimony. Is that correct?
That's correct, sir. I saw that last week, I believe.
And he was the fellow who was reaching in to stop the car from getting into gear. Is that
On the
right?
passenger side, yes, sir.
Was he at risk of great bodily harm or death if he had not gotten out of that car as quickly as he did?
Had the vehicle been put into drive, beyond question.
If, let me assume a hypothetical, if we have the facts as we have them here, and the officer sees Johnson in the car,
Yes, sir.
sees him struggling in the car and has a view of him, and further the individual is about to drive away, or at least attempt to drive away, with an officer who's in and out of the car, would that officer who sees him be reasonable in the use of deadly force in the face of Mr. Johnson's apparent risk of great bodily harm or death?
I'll object, Your Honor, as calling for speculation and improper standard.
The objection is overruled.
You may answer.
The question, sir, would be answered first by just understanding the basic decision-making process involving deadly force, and that is, can I reasonably articulate a belief that myself or another is in immediate danger of risk of death or great bodily harm? So if that's the standard, as an officer assessing the appropriateness of deadly force, an officer half in and half out of a vehicle that is about to be put into drive with the door open would certainly meet that standard of being in immediate danger of death or serious physical injury.
So an officer seeing that could shoot.
It would meet that standard, and an officer could shoot, yes, sir.
May I have a moment?
Yes.
Thank you very much. No further questions.
Thank you,
Right.
sir.
Members of the jury, we're going to take our morning break, okay? So it will be 20 minutes. Okay, you may step down.